1, 2, 3, 4, 5. 1, 2, 3, 4, 5. Okay, everyone's good? Great. No problem. Sorry? Ed is not taking any questions. He's going to just do yeah. Ed's going to make a statement. He's not taking questions. We have hard copies of the statement we can hand out to you after the fact. And then that will be it for him. If anyone wants to talk to any of the lawyers, you can let me know. And if that's... Yeah, sure. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Mic check. 1, 2. Good? Do I sound professional? Like I know what I'm doing? Thank you. All right, if you've got questions, let me know. Thank you.
Where's my guy? Fox News? Okay. Oh, there you are. Okay, great. You can speak. Sophia,
Okay.
Tell us about your experience.
It was really interesting being part of the judicial process and like serving on a jury. I thought it was really like both sides had great lawyers and did a great job, and it was a very interesting case. So it was nice to serve.
Can you say and spell your name for us?
I was on the jury, yeah. Yes. We thought really long and hard about the questions that were presented to us, and it was a really great group of people who we talked, we worked through everything as we were instructed to by the judge and by the jury instructions that we were given, and we ultimately came to what we thought was the right interpretation of the law that we were given.
What was it like hearing Ed Sheeran playing? Cool.
I mean, it's obviously cool to have anyone play music in front of you live. So that was like, an interesting surprise. It's an interesting case because you're comparing music to a sheet, but it was very cool hearing him sing in court, I guess.
What were the key factors for the jury in your decision? What were the most important things?
I guess the most important thing in our decision was that we were given the things we were supposed to consider, and we had the evidence that was given to us and only that to work with. And we had to answer the questions that we were given, which ultimately led to the judge's judgment, or that we were given. So, key factors were obviously the song as we're allowed to hear it, and then the deposit copy, which was in question, and trying to use their testimonies and the expert witnesses' expertise in the subject to try and best understand the similarities or lack thereof or differences in the two works, and try and make our best and most fair judgment with what we were given. I definitely don't think it was a case where you walk in the room and no one had anything to say. We spent a lot of time going very carefully through the questions and the definitions of everything in them and trying to answer them to the best of our abilities. So I think it was less about there being a lack of deliberation and more so of us wanting to be really thorough and get ourselves on a page that we were all very comfortable with, which didn't necessarily happen immediately. So there was a lot of back and forth. We all just wanted to make sure we were very comfortable with the decision that we were giving.
Did anyone start out being very strongly for the other side?
I think there's 7 people in the room, so everyone had opinions going in, but both sides had advocates, and then there were the people that were we were more in the middle and trying to figure out either way what was actually the best ruling of law in this case.
Can you spell your last name for us?
Neis, Neis.
Sophia, S-O-P.
Yeah. Sophia with a PH, Neis, Neis. I'm 23. Just graduated student.
Can we interview
can't be there if you're not in-house press. This is the in-house press only. You are. Gotta come on. Only in-house. Only in-house. In-house. Miss, you in-house?
Yes.
How you doing, guys? You alright? Oh, shall I put that on? Sorry. Do I talk? Right, Doug, why don't you just come here? Just come around here, go there. Go there. Sorry, he's my guys. Good morning, afternoon everyone. Thanks so much for being out here. I'm obviously very happy with the outcome of the case, and it looks like I'm not having to retire from my day job after all. But at the same time, I'm unbelievably frustrated that baseless claims like this are allowed to go to court at all. We've spent the last 8 years talking about 2 songs with dramatically different lyrics, melodies, and 4 chords which are also different and used by songwriters every day all over the world. These chords are common building blocks which were used to create music long before Let's Get It On was written, and will be used to make music long after we are all gone. They are in a songwriter's alphabet, our toolkit, and should be there for all of us to use. No one owns them, or the way they are played, in the same way that nobody owns the colour blue. Unfortunately, unfounded claims like this are being fueled by individuals who are offered as music experts in musical analysis. In this instant, the other side's musicologists left out words and notes, presented simple and different pitches as melody, and by doing so, created what I think we proved for all to see were misleading comparisons and disinformation to find supposed similarities where none exist. And I think we proved for all to see that they tried to manipulate my and Amy's song to try and convince the jury that they had a genuine claim. I'm very grateful that the jury saw through those attempts. This seems so dangerous to me, both potential claimants who may be convinced to bring a bogus claim, as well as those songwriters facing them. It's simply wrong. By stopping this practice, we can also properly support genuine music copyright claims, so legitimate claims are rightly heard and resolved. If the jury had decided this matter the other way, we might as well say goodbye to the creative freedom of songwriters. We need to be able to write our original music and engage in independent creation without worrying at every step of the way that such creativity will be wrongly called into question. Like artists everywhere, Amy and I work hard to independently create songs which are often based around real-life personal experience. It's devastating to be accused of stealing someone else's song when we've put so much work into our livelihoods. I'm just a guy with a guitar who loves writing music for people to enjoy. I am not and will never allow myself to be a piggy bank for anyone to shake. Having to be in New York for this trial has meant that I've missed being with my family at my grandmother's funeral in Ireland, and I will never get that time back. These trials take a significant toll on everyone involved, including Catherine. I want to thank the jury for making the decision that will help protect the creative process of songwriters here in the United States and all around the world. I also want to thank my team, these guys, who've supported me throughout this difficult process, and to all the songwriters, musicians and fans who've reached out with messages of support over the last few weeks. And finally, I would like to thank Amy. Neither of us ever expected that 9 years ago, from our wonderful writing session, that we will be here having to defend our integrity. Amy, I feel so lucky to have you in my life. Thank you. We need songwriters and the wider community to come together and bring back common sense. These claims need to be stopped so the creative process can carry on and we can all go back to making music. And at the same time, we absolutely need trusted individuals, real experts, who help support the process of protecting copyright. Thank you. Great. I'm gonna leave it to these guys now. I've made a mistake.
We have prior Cashman, legal team.
Cool. Nice one, guys. Thanks, guys.
Congrats, Ed. Ed, how do you feel?
I think they're tired of us, so that's okay.
Are there any questions for the legal team?
What do you say to those future possible? Are you guys involved in those cases as well, or?
We are involved in those cases as well. We will deal with those cases as and when we have to. We think they have as little merit as this case had, and we think the outcome of those cases will be no different. I think the ruling today proves exactly what it said. Ed Sheeran and Amy Wadge independently created Thinking Out Loud. They didn't copy anybody. There was no similarity between the songs, and that's not going to change in any other case involving those songs.
Can you talk a little about what this case had the potential of doing, and do you think that what do you think? Talk about today's win.
Well, I'm hopeful that today's ruling gives songwriters more comfort that they can continue to create great music using the basic building blocks that were at issue in this trial, with a little less fear of claims against them, for sure. So it's Eileen, Ilene, Farkas, F like Frank, Arkas like Sam.
You want mine too?
The real one.
The real name. Oh, Don Zakarin. Zakarin. That case is waiting on what happens with the first SAS case. Again, as I said, we never thought it had any merit. We never thought the SAS case has any merit. And we'll deal with those cases sequentially when they come up.
Do you think that Judge Stanton was correct to apply the stairway to Hockey rule here with regard to the deposit copy?
There's no question, that is the law. The Copyright Office says that's the law. It's not just the Ninth Circuit, it has always been the law. Unlike most people, I've been practicing since before 1978 when the copyright law changed. So I know what it was and I know what it is.
Were you surprised at the quickness of the verdict?
No, not at all. All right, thank you.
Thank you very much.
Thanks a lot.